Tomorrow marks the 57th anniversary of the signing of the 1965 Voting Rights Act. The landmark act removed legal barriers at the state and local levels, preventing African Americans from exercising their right to vote. Joining us to talk more this morning about the significance of the legislation is Dr. Eddy Carder, Assistant Professor of Constitutional Law and Philosophy at Prairie View A&M University. Good morning. Thanks for joining us.
Good morning, Rebecca.
So tell us a little bit more about how the voting rights of 1965 really build on strengthening 13th, 14th, and 15th Amendments. What's the significance of it?
Exactly. The 13th, 14th, and 15th Amendments are known as the Reconstruction Amendments. The 13th Amendment prohibited slavery. The 14th Amendment assured due process of law for African Americans. And most importantly, for our purposes this morning, the 15th Amendment gave Black males the right to vote. The Constitution itself does not grant the right to vote. That is a legislative right. But I would argue that really, even though the Constitution does not do so, the right to vote as a fundamental right is really inherent in the words, clauses, and phrases and the spirit itself of the Constitution. But interestingly enough, in reaction to the 15th Amendment, states began erecting barriers in order to obstruct African American males from voting. And so that's where the Voting Rights Act of 1965 came into play. Though it was many, many decades later, the Voting Rights Act was passed in an effort to limit states' ability to restrict the right to vote with regard to African Americans. So really, the Voting Rights Act is intimately related to events surrounding the implementation and approval of the 15th Amendment.
Right. And so, Dr. Carder, to your point, is what's left of the Voting Rights Act as we know it today as protective as it once was before?
That's a very, very good question. And the reality is that it is not exactly what it used to be. And the reason for that is because of a particular ruling in the case of Shelby County v. Holder. That was a 2013 case. In that particular case, some would even go so far as to say, and I think they're correct, that the Supreme Court really gutted the 1965 Voting Rights Act by eliminating the possibility or the requirement for federal observation of state legislation regarding voting rights. And that thereby opened up the way for states to find ways without federal limitations around providing voting rights for African Americans and allowing them access to the privilege and the right of voting.
Right. Now, Dr. Carder, unfortunately, we are short on time, but it goes without saying that this is something that is at the forefront of politics right now in 2022. In your opinion, do you actually believe that we need the voting rights of 1965 today in 2022?
Absolutely. Voting rights are under siege still, probably as more so than they have ever been before. Voting rights are being obstructed but because of partisanship, because of the vulnerability of technology, because of social media. Voting rights are especially being under attack in this day and time, and especially eliminating access to the voting booth of certain people groups, disenfranchising them. So absolutely, the importance of the Voting Rights Act in its original form is as important, if not more so, than it ever was.
All right, well, we'll leave it right there. We appreciate your time this morning. Dr. Eddy Carder, Assistant Professor of Constitutional Law and Philosophy at Prairie View A&M University. Thanks for your time this morning.
Absolutely.